Quitting for cause and employment insurance benefits. Most people contemplating quitting their job or having quit their job fail to seriously consider key legal aspects that could very well entitle them to significant money on their departure. When you realize that there is far more to quitting your job, hopefully you'll look at investigating your own situation with a knowledgeable lawyer, as the truth is far more complex than what most Canadian employees have been led to believe. Now let us proceed to one such aspect as we consider why is quitting for cause so important. Employees that quit their job for cause tend to be entitled to receive EI, employment insurance benefit payments, given the specific wording in the Canadian Employment Insurance Act, Section 30(1). A claimant is disqualified from receiving any benefits if the claimant lost any employment because of their misconduct or voluntarily left any employment without just cause, unless A, the claimant has, since losing or leaving the employment, been employed in insurable employment for the number of hours required by Section 7 or 7.1 to qualify to receive benefits, or B, the claimant is disentitled under Sections 31 to 33 in relation to the employment. The key is that the employee is not disqualified from the receipt of EI, such that they must satisfy the legislative definition of for cause to effectively claim their entitlement to employment insurance benefit payments, which can be a somewhat complex legal process that benefits from advanced preparation and legal representation from a knowledgeable lawyer. But what does for cause mean, as the Employment Insurance Act begins with the following legislative position, Section 29 sub C. Just cause for voluntarily leaving an employment or taking leave from an employment exists if the claimant had no reasonable alternative to leaving or taking leave, having regard to all the circumstances. And then proceeds to provide a list of 14 legislatively prescribed areas justifying for cause job departures, while the federal government's website provides a far more expansive list of 40 main reasons that the jurisprudence has historically considered in this regard, together with the department's interpretation and its perception of reasonable alternatives. From a legal standpoint, the key is the legislation, as opposed to explanations provided on the government's website or the department's internal manual that directs their staff in how they interact with employee claimants, although this can be a very frustrating process given government mandates to control outflows. The 14 legislatively prescribed areas justifying for cause job departures set out in subsection 14 sub C of the Employment Insurance Act are as follows. 1. Sexual or other harassment. 2. Obligation to accompany a spouse, common law partner, or dependent child to another residence. 3. Discrimination on a prohibited ground of discrimination within the meaning of the Canadian Human Rights Act. 4. Working conditions that constitute a danger to health or safety. 5. Obligation to care for a child or a member of the immediate family. 6. Reasonable assurance of another employment in the immediate future. 7. Significant modification of terms and conditions respecting wages or salary. 8. Excessive overtime work or refusal to pay for overtime work. 9. Significant changes in work duties. 10. Antagonism with a superior if the claimant is not primarily responsible for the antagonism. 11. Practices of an employer that are contrary to law. 12. Discrimination with regard to employment because of membership in an association, organization, or union of workers. 13. Undue pressure by an employer on the claimant to leave their employment. And 14. Any other reasonable circumstances that are prescribed. Now, some of these just cause circumstances are relatively straightforward and unambiguous, such as sexual harassment and racial discrimination, while others are more detail-oriented and subject to reasonable alternatives considerations, such as changes in work duties and excess overtime work. However, in my professional estimation, the most underappreciated yet most prevalent just cause circumstance may well be paragraph 11, practices of an employer that are contrary to law. And without delving too deeply into my rationale for this belief, this is something that I believe impacts an inordinate number of employees, in particular employees working in the province of Alberta, although there are also many employees across Canada who could raise this particular just cause circumstance for quitting their job and be entitled to receive employment insurance benefit payments. Naturally, this is heavily dependent upon specifics as a particular employment situation and the actions taken in advance of the employee's departure, given the department's posture on the phrase in the statute that the claimant had no reasonable alternative to leaving, as is evident from the insufficient proposals listed on the government's website, such that advancing this course of action is best undertaken with a knowledgeable lawyer and the recognition that there can be significant pushback from the government. Meanwhile, from this lawyer's personal perspective, Canadian employers contemplating departing their present employment, whether quitting, resigning, or retiring, need to assess their individual situation in advance of taking any action, as a knowledgeable lawyer can frequently discern a far more expansive case to pursue on behalf of the departing employee. Especially for the employee who is preparing to forego any pursuit of employment insurance benefit payments, making the inquiry to a knowledgeable lawyer really has no negative implications, as the employer was already prepared to walk away with nothing, while there may well be considerably more at play, and for which that employee is legally entitled to be paid out. If you are considering quitting your current employer or have recently quit your job, there are numerous aspects both pertaining to EI and other facets of your employment that you seriously need to discuss with a knowledgeable lawyer. Canadian employees need to understand what they are personally entitled to, which is highly specific and far too often overlooked. While a law firm like our own provides a free, confidential consultation addressing important legal considerations, demand serious consideration. Thank you.